The Canine and Feline Behaviour Association employs Britain's top seminar experts for your professional development. Seminars are exciting and stimulate new and modern ideas from Britain's top experts.
So under the Dogs Act of 1871, if a person fails to keep under proper control, it's a level 3 fine, which is currently £1,000. If the dog has been disqualified, and the person then has a dog after having been disqualified from having a dog, it automatically takes it up to a level fine 5, which is currently £5,000. And if there's any other orders that have been put on under the Section 2 of the Dogs Act 1871, they can also bring in these fines against those offences. Does that make sense? Yeah. Under the civil law, the standard of proof applies. And under civil law, the burden of proof is less than it would be for criminal. And this is the difference, that under civil, the burden of proof is less than it would be in a criminal. In criminal, basically, it's beyond reasonable doubt, whereas under the civil, there can be that little bit of doubt that comes in that sometimes makes it quite difficult for people to appreciate or understand why somebody's come to that decision. Under the civil, you're unlikely to get legal aid, whereas under the criminal law, as it stands at the moment, you could be entitled to get legal aid. And as regards to legal aid, that enables people to have specialists come in and expert witnesses, and it's paid for through the public purse, but the person that gets legal aid quite often has to pay a percentage of that money back to the public. On some occasions, it's very little. On other occasions, it's all of it. It's very much dependent on their status at the time as regards their earnings and what they're worth, really. But under civil law, you're not likely to get any legal aid whatsoever. It's dealt with as a summary trial, so it's in front of the magistrates, and it's the magistrates that normally deal with it. You do not go up to the Crown Court for it to be dealt with under the Dogs Act. There's no fine nor compensation available under the Dogs Act. So if somebody lays information in front of the magistrates and they're looking for compensation, they have to take a separate claim out in order to get compensation under this legislation. Whereas under the criminal law, one is entitled to compensation almost as an automatic right, and the magistrates can order compensation to be awarded under the criminal. Under the civil, you can't get a warrant to seize the dog, whereas under the criminal, you can. Under this legislation, it can apply to dogs that are dangerous to animals and humans. It's not expressly limited to where it applies. Under the civil law, it can happen in public or private. Dogs Act 1871, 3 aspects of the Dangerous Dogs Act. Ownership. Ownership deals with at the time it's in court, okay? And we've had occasions where somebody has handed a dog on to somebody else. An offence has been committed by that dog. They've then passed the dog on to somebody else. It's the ownership at that time when it goes to court. So if somebody else now owns the dog, they themselves could end up in court as a result of what that dog's done. Although there could be a defence, it's that person, the owner at the time, that is taken through under the civil law under the Dogs Act of 1871. And they look at things like not under proper control, and that's a matter of fact. And the facts are the facts that are laid in front of the magistrates in relation to the dog being in court for that particular offence or reason. So they look at the facts and decide whether or not that dog was deemed to be under proper control. Lawful visitors of property, they have a protection under this legislation, and sometimes it's not used enough where people do get attacked on their own premises, like postal workers, nurses, workers that come to premises. They could take out a civil case against the owner of the dog under this legislation. Lots of people don't. So it's a very, very useful piece of legislation if people knew the ability of it to be able to bring a hearing in front of the magistrates. Dangerous, whether the dog has a dangerous character, nature, disposition, or propensity. And as I said before, a single incident is likely to be sufficient unless it's exceptional. And there are those occasions where the dog can be quite aggressive and some of the attacks on the person are exceptional. Under those circumstances, it only takes that one occasion for this information to be laid in front of the magistrates. Next one is just a warning to let you know that there is a couple of pictures that are coming up that are quite nasty about a lady that got bitten by her son's dog in their own premise. Next slide, please. Can you see that? Or if you turn the picture, sorry, can you just turn the lights down a bit for us? And the next one, please, Mark. And the next one. This was the breeder dog that was responsible for those injuries. Basically, the circumstances surrounding this was that this lady was visiting her son. She'd made herself a cup of tea, went to sit in the settee next to the dog, leant over. The dog was asleep at the time. Leant over the dog to give it a kiss, obviously woke the dog up, and the first thing the dog's done is reacted whop, straight in the side of her face. My understanding is it's the first time that this dog had done this. Initially, the owner of the dog didn't want anything done about it. He did not want anything done. The mother was a little bit upset as regards what had happened to her, and they came to a compromise, and I'm sorry to say that the owner decided to have the dog put to sleep because he couldn't run the risk of that happening to his children or other visitors to his premise, and he didn't realise the intensity of what the dog was capable of being woken from sleep, bang, straight in. So the dog was destroyed. Not that particular dog, but the dog was destroyed. So again, looking at the Dogs Act 1871, the court powers available under this act is that the magistrates can decide not to put any orders on the dog whatsoever, or they can place a control order on the dog, or it can be a control order plus conditions, or they can ask for the dog to be destroyed or recommend that the dog be destroyed under certain circumstances. Disqualification of ownership of a dog is discretionary, and it's quite rare for them to put a disqualification on, unless of course there is a lot of antecedents in relation to the dog or the owner, or it's something that's quite specific and they feel that the best way to resolve the situation between the owner and the dog is for them to have a disqualification, and they can award costs as well. There are also additional powers to the magistrates under the Dogs Act of 1871, which provides enforcement provisions for any breaches of the control order that they've imposed on the dog. And they can, as I say, disqualify the owner from having a custody of a dog if they so choose. Before we do move on, is there any questions on what we've just covered? It's a lot to take on board, isn't it? It is a lot to take on board. And this is why I think it's important that owners should have some basic understanding about civil law and criminal law when it comes to the Dogs Act of 1871 and the Dangerous Dogs Act of 1991, and understanding the difference between the civil and the criminal, when offences are committed under civil and when they're committed under criminal.
CFBA venues are the best in Britain, air-conditioned and modern. We offer coffee, tea and light refreshments at all seminars. Seminar seats are booked rapidly, so do ensure your reservation online today.